welcome to another episode of the Akiona Law Podcast, wherein we talk about anything and everything that intersects with the areas of family law and divorce. And today I'm excited to have with me collaborative law attorney and mediator, Kristyna Larch. Kristy, welcome to the show.
Good morning. I'm so happy to be here.
Yeah, thank you for being here. So, Kristyna has years of experience working within the legal system. She has been an advocate for victims of domestic violence. She's also worked with victims of sexual assault. She's worked with family law commissioners. She was a court-appointed special advocate in dependency cases, and then she decided to become a lawyer. She's been a lawyer for 14 years, and she's a former divorce litigator, but now, again, she is just doing collaborative divorce and mediator. She's also a former president of the King County Collaborative Law, the King County Collaborative Law Group here within the state of Washington. Kristyna, did I leave anything out?
I think that's pretty complete.
Man, you've got like tons of experience.
I'm one of those people that has a hard time sitting still, and that's been a nice portfolio career. It's all fit together really well, built upon itself, and all of those skills from all of those different areas have translated into what I'm currently doing.
But I think it's fascinating how you have all that different experience and just these, you're just more than a family law litigator, and now you're transitioned over to collaborative law and being a mediator.
I really, really enjoy this work. It's frankly one of the reasons, or one of the things that I focused on in law school. Collaborative law was fairly new at the time. There had been a number of people here in the community that had been doing it. And really growing the practice area and the practice of collaborative law. And came out of school prepared to do that, went to work for a litigation firm because those were the people that I knew. I knew everyone in the court system at the time. And the firm owner, let me practice collaborative law. So I practiced litigation because that was where most of the need was, and then grew a collaborative practice while I was there.
Okay. So you've been doing collaborative law since you became a lawyer then.
Yeah.
So when did you start doing collaborative law full time?
It's always a question, right? What percentage of anyone's caseload
Okay.
is handled through the collaborative process? I would say about 6 months ago, I gave up the remainder of my litigation cases.
Okay.
So up until 6 months ago, I had a little of both, mostly collaborative for probably the last 6 years or so.
And you also are a family law divorce mediator.
Yeah.
Tell us about that. How did you get into doing that?
Right. So the type of mediation that I offer is facilitative mediation. And so the individuals are with me either on Zoom or in person, but we're face to face. And so it's interest based. We don't come in, neither of the clients comes in with positions already prepared. And we work through very much like in the collaborative process, gathering information, understanding the information, making sure that's the data set that's complete for both individuals to have the amount of transparency they need and to be able to consider all of the variables that are important to them and ultimately making a decision about how to allocate their resources between the two of them as they're divorcing and restructuring. Versus shuttle mediation, where people are in separate rooms and the mediator is shuttling offers back and forth. They've already come in with positions. I need to receive and I have a right to this. And the other person says the opposite.
Right.
And they're working from those two places. This is instead a much more holistic way of doing it. And there are many of us in the community that mediate this way.
Now, let me ask you this. Have you done shuttle mediation before?
I have.
Okay. And I can tell you didn't like it.
Well,
Fair to
it's
say?
funny. That's great. No, I did it both as an attorney for years in litigation because that's our go-to in litigation.
It is.
Yeah, and also used some of and it's funny because I'll give their names out even now that I'm mediating in a facilitative style myself, other facilitative mediators in our collaborative community who I really, really respect,
Mhm.
had used them over the years. And I always preferred to use them because people would spend 2 hours with their mediator at a time. It's more of a conversation. It's
Oh,
easier for most people to endure 2 hours of that business and of those conversations than it
right.
is for them to get thrown in a room after reading a letter from the other person that said some things that were probably really, really hurtful.
Yeah,
Because in building the other person's positions and setting the bar as high as they could,
right.
they naturally said things that hurt the other person.
Yeah, that's so true. Whenever we do our mediation letter, mediation brief, I always have to prepare the client. Okay, don't get upset. They're coming out and they're saying they're trying to position themselves in the best light possible. So they're going to say negative stuff about you. And if they're asking for $20,000 in spousal maintenance, don't freak out. They're just they're trying to go for the moon, knowing that you've got to come down and bargain. But yeah, it's just it's almost like such a gut punch to the client to be in that process.
It is. And what a horrible place to start a conversation. So then everyone shows up the next day or a couple of days later, ready to do battle. And you have an eight
Exactly.
hour day,
Yeah,
which turns into a 10 or 12-hour day, which is
right.
horrific for people.
It is.
Well, the mediator in that type of a setting puts pressure on each of them in their separate rooms and tells them each,
Yeah.
these are your risks. And the
Yeah.
attorneys, I'd always call the other attorney out in the hallway. Can we talk? Does your client have space to do X, Y, and Z?
Yeah.
And let them know too, where my client just does not. So again, with facilitative mediation, it feels that it removes a lot of the gamesmanship
The gamesmanship.
and it's much more
Yes.
straightforward.
Yes.
Talk about what you really want,
Yeah.
not what you believe you have to say, so that you can come down and agree to the
Right.
thing you really agree to. It eliminates, if people are amenable to that, all of that stuff in the middle.
Wow, you really described really perfectly the shuttle mediation process. And it's a stressful process, and it is the gamesmanship is frustrating, and it's especially frustrating too when you're dealing with a lawyer on the other side, and that's kind of entrenched almost in that gamesmanship, in that battle. Yeah, that's when we go to the 10, 12 hours.
Right, right. And I've been guilty of being the one.
Mm.
I so often was the one who would set the boundaries with my client and with the mediator and with the other attorney. If the parties haven't made traction by about X time, we should respectfully schedule another session and leave.
Mm,
Everyone's too tired, they're going to make bad decisions.
right,
But I have also been the person who got sucked into maybe they're going to be able to do it. You know what? If they haven't done it in the eighth hour, they need a break. They're not going to do it today. And if they do, they're not going to do it well. And they're going to wake up upset with the agreements they made.
right.
But with facilitative mediation, the other thing that's really different is that
Yeah.
people don't have attorneys present. And that's a really different dynamic because
Wait,
we
hold on
have,
a second. Can I pause you?
Mhm.
Are you talking about like all the time there's not attorneys present? Sometimes there's
Yeah,
attorneys present, right?
sometimes they are, yeah, generally not, but sometimes they are.
Yeah. Okay.
And that can happen in a couple of different ways or for different reasons.
Okay. So let me not, okay. So you were saying in the facilitative process, a lot of the times people don't have their attorneys present.
Right.
And what's the dynamic like with that? Because, as a person, I may feel like, oh no, I need to have my attorney present. How do I know I'm going to get what I want? My interests are being represented.
Absolutely. So, shuttle mediation, and again, it serves a purpose. There are things about shuttle mediation. It's also called evaluative mediation, that it's right for some people.
Yeah.
Um, One of the things that that does is it's a space where the attorneys are still arguing for the clients.
Yeah.
The mediator is talking directly with the
Right.
client, but the attorney is interjecting and they're arguing. But
Yes.
they're in a different room. So
Mhm.
the other spouse, the other partner isn't hearing what that attorney is saying about them. So there's a little bit of a shield, which is helpful.
Right.
In facilitative mediation, people are being encouraged to speak in a way that they can actually be heard by the other person. and the other person has space to hear, and the understanding can be checked, and then there can be a response.
Mhm.
But it is, even though people have a tendency to want to go to a place of argument,
Mhm.
I want what I'd like, because we try to not do that. Again, more of a conversation. What are their needs? Build on that. And they have to also be considering the other person's needs. So I do ask everyone, sort of a soft requirement, to have attorneys when they're in a facilitative mediation process, because they do need to be able to consult with an attorney and
Yeah.
get legal advice.
Mhm.
And I'll sometimes send them away with a question for their attorneys,
Mhm.
and it's transparent. And
Yeah.
I'll usually ask them to ask their attorney what they would advise the other client, if they had the other client, so that we can bring a fuller set of data from the attorneys and from the legal advice position back into the room.
Wait a minute, let me pause you on that. So you will have, okay, so like I'm the wife, right? And I'm saying I want $5,000 maintenance for, let's say, 5 years. So you're telling me, okay, go to your attorney and, oh gosh, I can't, my brain's not functioning. You said, you said something about you're gonna have me as the wife client go to my attorney and have him give me advice about whether or not the husband can pay me $5,000 spousal maintenance. I know I'm not saying it right.
No, it's a great way to ask that, though. Yes, and we do that transparently. So as the mediator, I have both of the clients in
Right.
all of the conversations. And I will say, I think here, that might be a data point that would be really helpful, especially if someone is struggling with whether it's their own ideas or a lack of clarity around the law, which is a whole nother topic, because the law and family law is so gray. It's all
Right.
discretionary.
Mhm.
And it really comes down to, would you like the court to make the decision for you? Some people need that. Or would you like to be the ones who make your own decisions? And that does involve things that work for both of you. But yeah, we'll have a very specific question quite often, not always. And
Uh-huh.
that's a great example.
Yeah.
Why don't you go and talk to your attorney about their ideas around duration
Uh-huh.
and amount
Uh-huh.
under your circumstances? And
Right.
again, please ask them what they would say to you if you were the other client, if they had the
If you're
other
the other
person.
client. Okay, like considering, because like in this scenario, the husband's like, I take home 6 grand a month. I can't pay you $5,000 a month. And so
Right.
the wife's attorney is just basically advising her, like, okay, well, I'm now representing the husband, and I would tell him that, if you're taking home $6,000 a month, if you're paying her $5,000 a month, you can't afford to pay your own bills.
Right. And that attorney's going to say things like, and the court won't make you do that.
Yeah,
Right. And
right.
so they'll also get some other sort of what's the word I'm looking for? Contours or boundaries around that, because their
Contour.
attorney, as their advocate and the one providing them with legal advice, can help them to look at those pieces, because it's never just this amount
Mm,
of support based upon this amount of income. Again, why there's discretion. And I also talk a lot with people about, and then it's helpful after we talk about what I'm going to say, for them to be able to have the conversation with their attorney, who is their advocate, who is providing them legal advice, is the idea that it's all a matter of discretion, especially when we're talking about something like spousal support.
yeah,
Very discretionary.
yes.
We talk about the statute. What are the factors the court has to consider? And a part of that is, and anything else. And then we also, so would you like another person, a third party who's the judge, even if it's a great judge? I have so much respect for the people on the bench. King and Snohomish County are the two counties that I practiced in. They work so hard. Most of the time they do their reading, and some of them even read it twice.
Yeah.
So not afraid of that. It's just that, would you ever like another person to exercise discretion about your life, no matter who they are? Or would you two like to figure it out, even though that requires some compromises? But we also talk about the standard for appeal,
Oh, you
abuse of
talk about the
discretion,
standard for appeal? Wow.
abuse, because
Okay.
I think it really helps people to understand the discretion of the court.
Uh-huh.
If the standard on appeal is abuse of discretion,
Right.
and you are given broad discretion.
Mhm.
How do you know when someone's abused their discretion?
It's tough.
Mhm. Not very often. You're not going to abuse it very often, probably, because the default is that you have discretion
And
and
when
you
you say
have to do something out of bounds.
and when you say you have discretion, you're talking about that family law judge has broad discretion to decide what's to decide what's fair and equitable in a family in a divorce
Mhm.
case.
Absolutely.
Broad discretion. What's fair and equitable? It's a really big it's
And
it's
isn't it right?
it's a big hula hoop.
Right. And how that person sees it
Yeah,
based on the facts that are before them and the rules of evidence that have shaped those facts and limited those facts or expanded them,
right.
and the things they don't get to hear because the rules of evidence exclude them. And I think sometimes, I hope it is helpful for individuals who don't know it's their first rodeo. They don't have experience doing this, it's their lives, to understand a little bit about what it means for someone else to have discretion. They can do a good job, they can do their job very, very well, but they're going to pick.
Yeah. And I think it's what's interesting is that, and I remember I had this problem too when I was a new lawyer and I was working with a new lawyer in a case, and I was talking to him about, oh, so are you going to continue to do family law afterwards? And he said, I don't know. I don't really like family law because it seems like the courts and the judges don't follow the rules. Like they don't follow the case law. And then I had to say, well, it's not what people don't understand is that there's no black letter, bright line rule in family law or divorce. The answer is it depends. It depends on the facts and circumstances in the case. It depends on your jurist and their own experience, because in family law, the court has broad discretion to do what's in the best interest of the children, to divide assets and debts in a fair and equitable manner. And that is such a huge pen stroke. And they have so much, what's the word? I'm not thinking liberally, but they there's that other synonym for when someone they can exercise broad liberty, but I don't want to keep on saying discretion. Um,
Right,
but they have a lot of authority within their scope, um, to make decisions in family law and divorce that doesn't necessarily follow black letter law, because you can't. That's not the way the family law court system and the case law is structured.
right. And it's really unfortunate for individuals who, they may have a good case, as
Right.
a litigator. So often I would meet someone, hear their story, ask some questions, and after interviewing them, realize, well, I'm so saddened by their circumstances and so concerned for them. Oh, they have great facts.
Yeah.
They have a great case.
Yeah.
And what a strange thing to say to another human being.
Yeah.
You have a great case because things are so clearly horrible. It's
Right.
really horrible.
Oh my
And
gosh.
because then you assume that the person who's hearing those facts is going to operate in a much more narrow range of discretion.
Right.
You assume, but it isn't always the case. And I think that people don't always realize that they don't get to say anything they want. They're not going to convince the judge necessarily, because again,
Right.
it's another person outside of your own head and
Mhm.
your own circumstances. And we bring ourselves when we're exercising our discretion, when we're making a ruling, when we're doing any of that.
Right. And I think that's, like the more I practice law, you're probably like this too when you're newer, you're like, we got to go to court. We got to go to court. Let's have the judge decide. And the more that I practice law, I'm like, no, I don't want the court deciding, because you don't know. You may have good facts, but you still don't know. And it's just so much more powerful for you to decide. And that's what I love about, like you're talking about this. And again, like you explain so well the difference between shuttle mediation and facilitative mediation, where the shuttle mediation, you still have that pressure from the median. Well, the pressure from the mediator in the sense that, well, if you don't settle today, then you're going to have to go to court, and this is how the court might rule. So still that subtle pressure to resolve things. And so, talking about facilitative based mediation, so I'm here, right? I'm the wife trying to get divorced with my husband. We've got two kids, ages 12 and 14. I was a housewife, so I need maintenance to transition back. And so you're starting off with me and my husband in the room. And then, so you start off with basically saying, tell me, Lani, what are your interests here? Are you putting it down like on a whiteboard, identifying like the wife's interest and the husband's interest?
It depends. So we usually will start with high-end goals, just like in a collaborative manner, so that both people have the opportunity, both of the clients, to become really clear on and create kind of their own vision board of
Okay.
what they would like things to look like
Yeah.
during their process, when they're done, and sometimes a ways out. And when we do that and we work with those high-end goals, and then they are interest-based, we can, as individuals, have a much better sense of where we're going, where we're trying to get to, what those goals are. And then we can find lots of ways typically to meet them.
Yeah.
Versus with a position, there's only one way to meet it. So it's often not going to get met.
Position, it's like, agree to my proposal or take it or
Right.
leave it. I've done that. I've done that in mediations. When you're going back and forth between your counters and our counters and offers and counter offers.
Yes.
I've told the mediator before, okay, this is our this is our best and final offer. Take it or leave it. Tell the other side that. Oh goodness. But okay, so we've got the high end goals, right? And so I've got spousal maintenance, I've got child support, I've got my own home. So in terms and this is just going back again to where we're not doing that 8, 10, 12-hour mediation where everybody's just dead. So we're kind of breaking it up where we're like, so you're asking me and my spouse, okay, we've got wife's high end goals, we've got husband's high end goals. What do you guys want to tackle first? So we say, I want to talk about spousal maintenance. So if we talk about spousal maintenance for 2 hours, do you then say, okay, and let's say we reach an agreement and you say, okay, do you guys want to continue going to talk about child support? Or do you say, let's just end here and schedule a second session to talk about child support? Because it is still tiring.
That
Even after
is such a good, yeah. And I apologize. I'm turning the sound off on my phone. I had a family emergency thing occurring earlier, so I had left it on, but I've turned it off, and I apologize for that.
I didn't hear
Um,
anything. I just
oh,
heard,
good,
I just heard my
good,
own voice.
good. Okay, good. I feel like, those dings and things like that can be so distracting. Which is a part of the conversation, by the way, about the returning to in-person that so many of us are having. I know you're involved in those conversations all the time. But what I do is we work from an agenda. And so every time that we're going to have a meeting, we have a very specific agenda for that meeting based on that couple, based on what's going on with them, so that everyone is prepared for those conversations. Um, then we will sometimes end early, and that may be because we've done all that we've come to do, or the individuals aren't really ready to move into the next part of the agenda. Somebody is really flooded. Someone now got some new information and needs some additional information, but it's structured in a very methodical way that's individually tailored. And I usually, if we're working on parenting, we typically won't work on that during a financial meeting.
Yeah.
It'll be one or the other, because I think that's very hard for people to shift from those two spaces.
It is hard.
But we'll often do it where we're talking about property as one meeting. And then at the next meeting, we'll talk about support, usually spousal and child support. And then often we'll come back and pull all of those pieces together. And sometimes we may be pulling some aspects of the parenting plan back in at that meeting. But it's always thoughtful and tailored to who are the individuals and what do they need and what's going to work well for them, because everyone is so different in how they process and function and what their tolerance is for conversations.
And Christy, you mentioned the term, just to kind of define things for some people. You mentioned the terms flooding, and I think you also talked about holding the space. Can you explain what those terms mean?
Right. So when someone's flooded, they have a really hard time processing. They don't even always realize it. The data that's in front of them, even if it seems like simple data.
Yeah.
the words the other person is saying. It's sort of like all the blood flowing to one center instead of needing to be out in all the extremities.
Yeah.
And at best, sometimes someone can let me know when they're flooded, which is really lovely. They
Wow.
can say, I'm feeling this.
Okay.
Or they can tell me. I'll sometimes ask, again, this depends on the individuals that I'm working with and why I may or may not ask. Um, how will I know? Can you give me an idea of what I might see or experience when you're feeling flooded? Because many people, it isn't obvious. They don't wear it on their sleeve. And so that we can look for that. But I do find that a lot of people, because the three of us develop a relationship together. And the idea is that we have a high level of trust and the ability to be vulnerable and the ability for it to be a safe space so that someone can say, I need a break. I'm feeling really flooded. I just stopped hearing what that person was saying. I can sometimes see it in a person will repeat something, or it's clear they're not responding to the question the other person asked or the idea that the other person expressed. And so sometimes that'll give me an opportunity to check in with them.
So you'll be like, let's take a 10-minute break for a second.
Yeah.
Okay. And then can you talk about holding the space for someone?
Oh, yeah. So holding the space looks a little different depending on the individual, who it is that I'm working with. It in one way, it manifests as a space where they can both come and be heard.
Okay.
So one person speaks, I might think it's really clear what I just heard.
Yeah.
Check in with the other person, because for the other person, it may not be as clear because they have a history together. They
Yeah.
might be flooded. They might
Right.
be hearing the dialogue in their own head. It's just three human beings sitting at a table together.
Right.
And the other piece of that is if someone has said, I have a tendency to cave and say yes too easily to the ideas of the other person because this is just so uncomfortable for me to have to do any business with them. It always has been.
Um,
And so it may be that I see something happening and we pause and we either take a break or we just verbally note it. I see this happening, or I wonder if when I see you do this. So different ways that we can do that. Holding a space, sometimes it's boundaries.
yeah.
If someone is supposed to go get legal advice and come back and bring that data back to the meeting, so there can be a deeper and more, I guess, a broader conversation with more data points. And they haven't done it. Part of holding that space might be rescheduling,
Okay.
because the other person may be feeling really, really frustrated that the other spouse hasn't done the homework the way
Ah,
they understood it to be assigned.
right.
So holding the space, I'll use that in a lot of different contexts, but it literally is meaning we have all agreed we would do this a certain way. We're going to do it the certain way, and I'm going to be the one who monitors that and watches that along the way.
And I noticed you use the term data points too. Can you explain to the listeners, to the layperson, what does that mean when you say,
Right. So we often think of data points as an account balance or a
okay,
date that we obtained that account balance.
okay,
But data points are other things as well. If we're talking about a house, it might be a house that had a tremendous amount of deferred maintenance. And both of the individuals say, yeah, we know there was a lot of deferred maintenance. And so some additional data points they may need to get are, what would it cost to repair this? How might it impact sale if they're selling at the time?
uh-huh,
But data points are also, why does something matter to someone? So it goes again to those interests and needs. It's more values based. And so some data points are value based,
ah,
and really understanding why something is important to someone is another type. But another type of data point is the law. And as you talked about, the law is not magic in family law.
mm,
It's not. It's a lot of experienced people working based on their experience, both in the court system and in the collaborative process, in a voluntary process. So a lot of times a data point will be the legal point of reference.
right,
What do the attorneys say? Sometimes the attorneys will give very similar advice if they understand the context and have the whole picture.
Mhm. Okay.
So all of the data points amount to something, a bucket of information
Yeah.
that allow people to make really good, solid decisions that are what we all refer to as durable,
Wow.
because they're agreements that they're going to want to abide by once they become a court order, once they become a signed property settlement agreement.
Okay.
Because they made them knowingly, willingly, with a full understanding of all of the varied data points.
Yeah. That's that's a beautiful explanation. Were you ever a teacher? Yes. You explain things so beautifully.
That is a huge compliment. Thank you.
No, I feel like you should be like a law school professor teaching the differences about mediation and all of this stuff. Oh my gosh.
Thank
Um,
you.
so just to kind of recap in terms of this facilitation mediation
Yeah.
process, you know, because if I was a person looking to get involved with this, it kind of sounds like to me that first meeting is you're talking about identifying what are your interests, what are your high-end goals. Like for a wife, a high-end goal would be, you know, to have my own place with the kids. So that's what you're doing at that first meeting. You're identifying interests, high-end goals, and then let's set our agenda for the next meeting. Is that correct?
Mhm. Pretty
Okay.
much. Sometimes I'll meet with people and we'll use sort of a hybrid agenda or a check-in agenda initially, depending on how we met, what they've done in the interim, and what the circumstances are. Because again, we want to be really thoughtful with both the use of the resources, and I always think about people's capacity to work in a voluntary process. And so I want to do the things that I can do to be aware of what they need to work at their maximum capacity, meaning sit and hear from the other spouse, sit and share ideas openly, or say, I heard that, I don't know yet, I need some time to think about it, whatever it may be, so they can be at their best.
Mm.
Um, but usually what we'll do is I'll give them homework when they first hire me, and we'll set the first meeting based on that homework likely having been done, where they've said, I think that's about enough time.
Right.
And so I'll put all their financial things together in a spreadsheet or in a report. And then when we have the first meeting, one of the things we will do after we talk about the high-end goals, if it's a financial meeting, is we'll check through the data and see what else either or both of them need to know in order to start working with their financial data.
Okay. And so then I guess in a typical facilitative mediation process, it sounds like there could be, if you're, especially if you're dealing something with kids, right? We've got to deal with custody, we've got to deal with the house, we've got to deal with spousal maintenance, child support. It sounds like best case scenario, we're talking about 5, maybe 8 meetings, sometimes more, of course.
Right, right. And I have some people who will do it in fewer meetings,
Ah,
but
with
I
all
always
these
let them
things.
know I can't know unless they've told me certain things initially.
Okay.
But quite often that just doesn't manifest. People don't know, and I would have to have a crystal ball. And so I always have my eye on, could we do more in this particular meeting? I've got a couple of couples right now where we're doing 1 hour meetings,
Ah, okay.
which is not, I don't usually do that, but for them, that makes a lot of sense. And so we're just having essentially conversation about these things for a shorter period. They'll go away, check in with the trains, etc., come back and have the next. But I think for people to expect to spend 5 to 8 sessions figuring out all of their agreements and arrangements and understanding their data and their information mutually to make those arrangements that are for quite some period of time, usually, depending on what part we're talking about, that they would spend 5 to 8 2 hour meetings over a period of time is actually really sensible.
Yeah, yeah.
Yeah, and I think for
I like
most of
that.
us, we can see that. I think that's a hard thing for people when they first hear that.
I think it's a hard thing, but at the same time, you know, we've done this and I know that the capacity, it's 2 hours because then it's so emotionally tiring and taxing. But
Yes.
And I'm an impatient person, like I want to get things done. But with these types of things, right, there's just so much thought that comes into it. Um, if you can, yeah, burnout is a real thing in this type of scenario.
Absolutely. And I didn't mention in this context the use of other professionals.
Mm,
But I think there were some other things that you and I are going to talk about, and we'll talk about those professionals. But I often, even in a mediated session, I'm always assessing for whether there is value to clients of having an interdisciplinary team. And so sometimes, we can talk about this or not, I say, because this is one of these things where it gets a little more in depth. We might use a collaborative participation agreement for mediation,
yeah,
so that there's an even higher level of transparency involving attorneys who aren't present in those mediation sessions.
yeah.
Um, and the other reason is because, we have fabulous child specialists. We have fabulous divorce coaches and parenting coaches. And we have fabulous financial neutrals. It just depends on, what it is. So I'm always, when I meet people, assessing for, who are the people that could help them to do this in a way where they're not only efficient, but they're effective. And again, have created something really durable with the support that they need that's unique to them.
You know, how often, and we're talking about facilitative mediation, how often do you use some of those professionals? You talked about a divorce coach, a child specialist, a financial neutral.
Um, oh, that's such a great question. It's a
Oh,
hard one to answer because it is always on my mind.
yeah.
So in terms of how often do I assess for that? Always.
Yeah.
How often do I use them? It really just depends on the circumstances. So sometimes I'll have people who they've already met a parenting coach.
Oh,
And
wow.
so, yeah, so they have the advantage of, using that person for their parenting plan. And then I'll work with them through the financial pieces and the legal pieces.
Mm,
Um,
okay.
Sometimes I'll have people where their particular circumstances, it just makes sense to have two separate professionals working with them and really separating the parenting and the finances. So there are just unique reasons. So how often is a great question. I don't actually have a number for.
Yeah. And let's going back to these professionals, can you let our listeners know out there, like we talked about the financial neutral, we talked about the financial specialist, no, the child specialist, and the divorce and the parenting coach or divorce coach. Can you let the listeners know out there, I guess define what each professional is and why would you want to use them?
Absolutely. So I think the easiest way to answer the question is to shift process.
Okay.
So in a collaborative process, as you know, in a collaborative process, you have an interdisciplinary team. They
Yeah.
are all working for the couple, and this is for the listeners. The parenting coach is also the divorce coach. So even if people don't have children, they have a divorce coach. It's a mental health professional who is specifically trained to do this particular work. And we all get to know each other, we all build skills with one another, and we all work together because we trust one another. And so it's a team approach for clients so that they have the interdisciplinary team to do a really thorough job for their family and for themselves. And so the divorce coach will do anything from managing emotions and conversations, helping people to ideally be at their best doing their business together when they're in the room together. When they're working as a parenting coach, as an attorney on a collaborative team, I love the parenting coach role because clients get to sit with that one neutral in that person's office and work through things that the attorneys would have traditionally done with them. And I think that's a great setting for that work.
Like a parenting plan.
Yeah. And so we'll have them create the whole thing with the parenting coach.
Yeah.
A child specialist is someone who, if, for example, parents might be working with a parenting coach, they might be working with a mediator and doing a parenting plan with their mediator. Um, the child specialist is someone who they'll meet the children as well as the parents.
Okay.
And the children have a space where they can say something to, again, a mental health professional who is going to soften that and really protect that information when they take it back to the parents, to give the parents additional data to make decisions with about the children and for the children and for themselves as parents. And an example for me is one years ago, one of the child specialists that we all work with met with a family and the children, and the other attorney and I had known this couple for quite some time because this was probably midway through their process when they were ready to work on this piece, and said, something I learned about your children is they really miss the tactile experience of the other home, and explained what that was to the parents and to both of the attorneys. And the parents were able to do very simple things like the same set of sheets in both houses.
Oh,
So when the child, so I apologize, it was two children, but one child with this particular concern, put their head down at night, it felt the same across households. And that comfort in from that small thing, but that was important for this child.
yeah.
So the child specialist is gathering data directly from the children. They're not asking them who they want to live with. They're not going to write a report to the court. They're not telling the parents exactly what the children said, but they're bringing that additional information in. I noticed about your child. And there are things that as a parent, there are parents who often will know my child has very high tactile needs or discomfort or whatever it may be. But this person as an outsider is getting a fresh look at their children.
Right.
And so for parents who are like, I would have never thought of that because my child just goes to sleep.
Yeah. Yeah. It's kind of with that child. Like I always kind of think the divorce coach helps is the emotional interpreter translator, especially when
Mhm.
people are flooded. And then the child specialist is gosh, and I just had it and I just lost it. But it's essentially um it goes back to what you were kind of saying fresh eyes, because like you were saying, sometimes like, oh, as a parent, yeah, my child just goes to sleep, but they provide that objectivity, like, oh, this aha, kind of like, oh yeah, oh aha, about about your child that you know as a parent, but you just internalize it so much. It's almost like breathing air. You don't kind of stop and think and define what it is.
Right,
That
right.
makes sense.
Yeah. So they do a lot of that. They can help parents to make decisions by having some additional, pardon me, data, having met directly with their children.
Yeah.
And also to allow the children to maybe say things that they can take back for the parents to use in a constructive way
Uh-huh.
without having to see that thing. They can provide a bit of a buffer. And an example might be with a teen.
A teen.
And the parents can then try to work with that.
Ah, those teenagers.
So that's another layer that's sometimes important. The other thing is, in a collaborative matter, we have the certified divorce financial analyst, the CDFAs.
The financial neutral.
Right,
Okay.
right. And so people have a neutral person looking at all of the finances.
Yeah.
And that person is essentially a clearinghouse, which might sound like not a big deal, and it really is, because you can either have two attorneys being your clearinghouse and hope they can agree about the data and how much of it, or you can have a neutral that you do all of that with, and it's far more efficient. And that's all they do.
Yeah.
Then they also are going to be the ones that are the holder and keeper of the data.
Yeah.
So
The
they're going to
financial data.
compile everything.
Financial.
Yeah. Everyone will work from that one place and make sure that it's an agreed universe of data. And then they can help to look at how might that look if it's allocated that way as these two people are thinking about it,
Yeah.
and be able to illustrate it in a certain way so that someone who maybe isn't, everyone sees and visualize things differently.
Mhm.
Illustrate it in a way that everyone again can be on the same page about what is it we're actually looking at, that we think we're discussing, that we think we might be doing in allocating our assets and our income resources.
And the thing I like about the certified divorce financial analyst is that, when you're attorney and you're trying to structure a fair and equitable settlement at mediation, I don't know if the monies you receive now, I don't know what that's going to look like or what you need 10, 20 years from now. But the certified divorce financial analyst, the CDFA, can run that those projections out, which to me, I would think, um, is a true value. Because I don't want to know if I were a divorcing person, I don't want to know what's fair and equitable right now. What is that going to look like 20 years from now?
Right. Some people really, really like that. I tend to be someone who I like people to use their financial planner
Oh,
when they're going to make longer term decisions because, and that's another thing on a collaborative case, the collaborative team is having transparency around use of other professionals like that. If someone's using a financial planner, they'd like to. We have so many who are collaboratively trained, who are a part of the collaborative community. So they are working on the problem solving part of things. They're at the table in the problem solving as opposed to creating positionality or
right.
planning an isolation of the reality or in isolation of everything. So yeah, the CDFAs can do that modeling.
Modeling.
And sometimes we'll have people work with their financial planners and then bring that information back.
Yeah. And I guess I'm talking about the aspect, a lot of times I've used CDFAs, they've had that experience as being financial planners
Yes,
also.
yes.
So then you
Yeah,
get the best of both worlds.
yeah. And I think for some couples, it's helpful for them to have that. I tend to work with a lot of people who they don't opt for that because of all the assumptions that have to be used along the way.
Yeah,
It just depends on the individuals. But
right.
you're right, for some people that has a lot of value and you're not going to get that from the attorneys. We just don't do that.
We don't do that. But another thing I like about the CDFA is that it really kind of usually in a marriage, right? One person is almost like in control of the money, but just they're used to just handling the expenses and the other person doesn't. So when the person wants spousal maintenance or something like that, sometimes they don't really understand the money coming in and the money going out. And it's not the husband wants to shortchange you. The husband legitimately can't pay all of these bills and meet your desired financial need as well. And the CDFA can really break it down and be like, this is the money coming in after taxes and after these bills and these bills and these bills and these bills. This is what's left over. So it really kind of illuminates the, you know, the finances of the household and what's doable and what isn't doable when we're looking at spousal maintenance and child support.
Absolutely, especially as people are creating two households.
Yes,
They have an
that's
entirely new setting.
two households now we're doing.
Right.
Yeah. Um, well, thanks for going over explaining those different positions. I kind of wanted to again just kind of circle back to the whole process of facilitative mediation, and we were talking about scheduling these maybe anywhere 5 to 8 meetings, 2 hours, just to kind of in terms to keep the momentum going. We're talking about scheduling these meetings on a weekly basis,
We
every
usually
other week.
schedule a couple of weeks apart at
Okay,
least.
a couple
Some
weeks.
people
Okay, to
schedule
do the
3 to 4
homework.
weeks apart, depending on how
Ah,
much time they need for homework in between.
right, right. Okay. Yeah, that makes sense. And so at the end, and now we're going to circle back on to the end of this process, are let's say these people don't have attorneys, so they don't have their attorneys to prepare the final orders. Are you preparing the final orders for them? Or are you just
Yeah,
making
generally I am. And if they have attorneys and they've authorized me to talk to their attorneys, I'll always ask the attorneys if they have a preference as well. And I provide them in a Word document and I let people know your attorneys are going to possibly want to make edits.
okay.
They're going to give you final advice. And I just want the attorneys to have the fluidity as they work with their clients and the clients to have that fluidity. But yeah, I'll put their agreements right into the property settlement agreement or any final orders because I don't see the reason to make people have to cut and paste that when they've made all of those intricate decisions
Mm.
that are just being stated in that format.
So you're doing the final divorce order, the child support order, the final parenting plan, the property settlement agreement.
Right.
Wow, that's really valuable.
There is a lot of efficiency, and I just never want anyone to think that in doing that, they can cut out attorneys because
Mm,
they do still need, attorneys offer so much value, even if they've had a light touch.
yeah.
And so when I'm working with clients and I'm not the mediator and I'm one of the attorneys representing or actually consulting for or with a client who's in mediation, I want to have as light of a touch as works for them. And so when I get those final documents from the mediator, if they put them into the documents rather than a memorandum of understanding, I can see all the parts together, the nuances of it, make sure it really all works for my client in the full picture. And then if there's something that needs to be altered, I can get a sense from my client of how the other client might feel about that. Or maybe I've been able to talk to the other attorney because of the agreement we all have. It just depends.
Yeah.
How that works. So yeah, I do, but they still should run them by their attorneys just to make sure that they have independent legal advice.
And if someone doesn't have an attorney?
Once in a while, someone doesn't, and that's entirely their choice. They have sufficient time to review things, and that's part of the process that's really important to me, is that no one is ever rushed or coerced into signing something. It happens on a time frame that works for each person.
And you mentioned a memorandum of understanding. Can you explain that?
Right. So sometimes when people mediate, and this is perfectly normal as well, and again, it's an option that I offer, their agreements will be put in a writing that just isn't in the final documents.
Ah,
It's separate from that. It may be as comprehensive, and then they sign that, and that gets turned over to their attorneys, who will then put it into the final drafts, into the final orders.
oh, okay. Now, for the it sounds like the memorandum of understanding is similar to that CR2A settlement agreement.
Very similar. And anytime, so in facilitative mediation, and really, I'm going to say in all mediation, it's a little more nuanced than that. No one is signing anything until they get to the end, and they have
Ah,
global agreements. And so they've been able to measure the whole thing together and make sure that every part of it works and that it all works together for each of them. They will wait and sign it until it's complete. And again, after they've talked with attorneys and received advice, because it's binding once it's signed. And that's that court rule that you're talking about, which is once parties have signed something, if they're not represented, and if they're represented, they and their attorneys have signed, it's enforceable.
yeah.
And the court's generally going to uphold whatever those agreements are. So in mediation, regardless of whether people are represented, we're really thoughtful about the pacing of that and making sure that structurally people have all the information they need to have before they say yes to something.
Are you, so after each meeting, are you just kind of doing like a meeting summary, kind of like in collaborative law, right? We have a,
It's a great
yeah,
question. Yeah, because some mediators do that. I tend to not. I'm in the camp of mediators who do not. And the reason is most people are taking their own notes in a way that is helpful for them. The notes that I'm taking are to track process, to remember something about a conversation that happened that's going to be helpful for everyone later. But they're geared towards what the work that I am doing for them. So I will prepare a meeting summary if people want it. The reason that I don't, and this is always, there are right and wrong pieces to both ways of doing this.
okay,
When you prepare a meeting summary, it often isn't yet agreements. It's we considered, you considered, you've asked for some additional data, you're going to do this next. Again, a lot of that people have just written down because most people will take a note that I need to call the realtor with my partner tomorrow.
right.
And we agreed that these are the things we want to ask them. When you send a meeting summary, and again, there's no right or wrong. It's, there just tend to be two camps of
Okay.
this. When you send a meeting summary, it can do a couple of things. Number one, sometimes no one reads them. So it's something that someone paid for that no one read. And then the other thing that can happen is someone forwards it to an attorney who
Oh,
they didn't tell anybody they were working with,
oh,
who isn't collaboratively trained,
oh,
who they have not bothered to invite
ah,
into the process transparently so that
yeah,
that attorney can have context.
yeah.
Um, So it's just a part of keeping it private for people, keeping it streamlined, keeping it cost effective. But I will always ask, and there are times where I will very specifically offer, because in that moment it seems it would be of value to people and of more help than hindrance.
Especially if there's just a lot discussed in a meeting.
There is.
Yeah. Are you always doing the memorandum of understanding at the end?
At the end of a mediation process,
Yeah.
usually we're doing final orders.
Okay.
So property settlement agreement, all of the things that would be in that memorandum of understanding in the full context.
Mhm. Well, so it sounds like you're only doing the memorandum of understanding if you perhaps aren't preparing the final orders.
Yeah, that's the only time I'll do that. So that again, there aren't additional layers unless someone had a need for that layer.
Okay, got it. And Christy, how can people get in touch with you to work with you as a collaborative law lawyer or to have you be their mediator?
Yeah, through my website, it has a contact button, larchlaw.com. I haven't posted recently, but I also try to put small blog posts or information for people about some of the common questions that come up usually around the law.
And Larch is spelled Larch, law, law.com.
Yes, yes,
Okay.
larch like the tree.
So that's the best way for people to get contact with you then.
Yes,
Great.
and then usually what I'll do is I'll set up a short meet and greet with people so that I can meet both of the spouses. They can ask me questions about what is this process, especially as it pertains to them. And the three of us get a sense of whether we want to work together.
Oh,
And
okay.
then I'll have them sort of step away and talk amongst themselves and then let me know if they want to work with me. Usually they're people I want to work with because usually they've either looked at my website and we have similar views about the world,
Right.
and how we treat each other, with the transparency and compassion and honesty. And
Yeah. Yeah, I love that. Transparency, honesty, compassion. That's that should be the model for getting divorced nowadays. Instead of, I'm gonna win at all cost.
right, right. And it adds to the expense when there's a lack of transparency because
Sure
someone's having
does.
to struggle to get the information they need from the other person. So I really appreciate when people are able to recognize the other person needs the information to make decisions. It's not going to go any faster without it.
And Christy, thank you so much for your time today and explaining the process of mediation, shuttle mediation, and facilitative mediation, which is what you do. Um, just amazing information you've given us. And before you go today, Christy, can you tell us a fun fact about yourself that maybe some wouldn't know just by looking at you or
That I like that. When I was younger, old teen, I was a figure skater. And then I stopped for a while, yeah. And then I stopped for a while, and then I went back as a young adult and did it for a while again. And it was the funnest part of my day. And I'm old enough, but it was when we also had to do compulsory figures. So you'd rent a patch of ice and you actually had to do figures, and then you would get your open freestyle time on private ice with the other freestyle skaters.
That's wait, so you were competing as a figure skater?
I know I did not compete because I left the first time before I got to that point. And then, so I put all of that effort into it to not compete
You
because I loved it.
so you
Um,
can do like those crazy spins and stuff?
yeah, yeah, it was
That's
like
crazy.
flying. It was like flying. It was the most amazing feeling. So it's funny, I haven't thought about that in a while.
Oh my gosh, that is a fabulous fun fact. And folks, that was a completely that she did not prepare for that question at all. That's completely off the cusp. Well, thank
Oh
you
my
so much,
goodness.
Chrissy. It's been a pleasure.
Well, and thank you so much for having me. I so appreciate you take the time to do these. These are really just a great way to get information out to people.
Yes, and that's the whole purpose, just to get that information out. Oh,
Take care.
thank you so much, Chrissy.
You're
That was a great way
welcome.
to end today.
Thank you for having me.
And for those of you out there, thank you for listening to another episode of the Akiona Law Podcast, and hope to have you back next time. Until then, be well.
The information in this podcast is general advice only and should not in any respect be relied on as specific legal advice.